Good day, everyone. I am Abegail Eds Goc-ong, and I'll be tackling today about examining the concept of importation under sections 100 to 110 of the Customs Modernization and Tariff Act and analyzes when customs liability attaches, as clarified by Supreme Court jurisprudence in General Register number 94262, decided on May 31, 1991. So let me talk about first the case background. XYZ University imported laboratory equipment from South Korea intended for educational use. The shipment arrived at the port of Davao and was unloaded into a customs controlled facility. Before filing the import entry, the university requested a delay due to internal procurement concerns. So during this period, no import entry was filed, no customs duties and taxes were paid, and the goods remained under customs custody. Despite this, the district collector of customs issued or demanded payment of duties and taxes. The importer argued that importation had not yet begun because the goods had not been released and no import entry had been filed. So, let me identify the parties. Importer, XYZ University, and the government authority is the Bureau of Customs represented by the district collector. The principal customs issue is whether importation had already commenced, thereby making the importer liable for customs duties and taxes, despite the absence of an import entry and the non-release of the goods. We have three legal questions arising from the case, and the first one is when does importation legally begin and end under the CMTA sections 100 to 110? Second, does the filing of an import entry determine the commencement of importation? And third, is importation legally terminated or merely suspended while goods remain under customs custody without payment of duties and taxes? Let us let this answer the questions. Relevant relevant provisions of the CMTA, Section 100, importation defined. This provision states that importation begins when goods enter Philippine territory with the intent to unload, whether for consumption, warehousing, or admission. So the law focuses on physical entry and intent, not procedural acts such as filing an import entry. The purpose? To prevent importers from evading customs liability through technical delays. Section 101. When importation ends. Importation ends only upon full payment of customs duties and taxes and lawful release of the goods by customs authorities, and its purpose? To ensure that government revenue is protected before goods are released into commerce. Section 102. Imported goods subject to duties and taxes. So all imported goods are subject to duties and taxes unless expressly exempted by law or free importation. So importation for educational use does not automatically confer exemption. Section 103, importer as declarant. So the importer or owner bears responsibility for compliance with customs laws, including payment of duties and taxes. Section 104, goods under customs custody. So once unloaded at the port of entry, goods are deemed under customs custody, regardless of whether an import entry has been filed or release has occurred. For sections 105 to 110, the general relevance, so these provisions reinforce customs authority, enforcement mechanism, and the requirement that goods may only be lawfully released after full compliance with customs laws. Now, let us apply the jurisprudence. General Registered Number 94262 rather, Feeder International Line PTE Ltd versus Court of Appeals, decided on May 31, 1991. I hope I pronounce it right. The story of the case. In this case, the foreign vessel M/T Uluwai owned by feeder international shipping lines of Singapore, departed from Singapore carrying oil products bound for the Philippines. Instead of proceeding directly to its declared port of destination, the vessel anchored in Iloilo without notifying the customs authorities. So, when customs officials boarded the vessel, it lacked essential shipping documents, and surrounding circumstances indicated preparations to unload cargo. So, as a result, the vessel and its cargo were seized and forfeited for illegal importation. The forfeiture was affirmed by the Collector of Customs, the Commissioner of Customs, the Court of Tax Appeals, and the Court of Appeals, prompting the petitioner to elevate the case to the Supreme Court. The Supreme Court ruled that importation begins when goods enter Philippine territory with intent to unload. Intent to unload may be inferred from facts and circumstances, for future proceedings are civil and administrative, requiring only substantial evidence, not proof beyond reasonable doubt. So the court emphasized that importation does not depend on actual unloading or filing of entry, but on entry into the Philippine jurisdiction coupled with intent. The doctrine directly supports the principles that customs liability attaches even before release. So once goods enter Philippine territory with intent to unload. So this prevents importers from avoiding liability by delaying procedural compliance. Let us go back to the issue. For the Iraq method, is XYZ University liable for customs duties and taxes despite the absence of an import entry and the non-release of the goods? So, rule again, under CMTA Section 100, importation begins upon entry with intent to unload. Under CMTA Section 101, importation ends only upon payment and lawful release, and General Registered Number 94262, filing of import entry and actual unloading are not controlling. Let us analyze. In this case, the goods entered Philippine territory and were unloaded into a customs-controlled facility, demonstrating clear and intent to import. So the goods remain under customs custody and no duties or taxes were paid. Applying both CMTA provisions and jurisprudence, importation had already begun but had not yet ended, and the absence of an import entry merely suspended release, not liability. So, in conclusion, XYC University is legally liable for customs duties and taxes, notwithstanding the absence of an import entry and the non-release of the goods. And the final legal position, based on the CMTA sections 100 to 110 and the General Registered Number 94262, importation begins upon entry into Philippine territory with intent to unload and ends only upon payment of duties and lawful release. The district collector's assessment is therefore legally valid. And as a future licensed customs broker, my professional advice is as follows. Importers should promptly file import entries upon arrival of goods. Second, customs duties and taxes attach upon importation, not upon release. Third, goods under customs custody are already subject to customs control and liability. Proper compliance prevents penalties, ensures efficient clearance, and safeguards government revenue. That would be all. Thank you. And this concludes my presentation on importation under the CMTA sections 100 to 110 with jurisprudence. Bye.